May it please the court. Your Honor, opposing counsel, members of the jury. It looked like just a toy until it took a child's life. This could be a picture of Joey Davis riding his first bicycle. It could be Joey Davis's acceptance letter into college. It could be the birth certificate of his firstborn child. But unfortunately, we will never know what could have been, because instead it's the autopsy report of Joey Davis, 2 years old. Now, Joey Davis was taken to the hospital on August 8, 2009, complaining of stomach pain. Stomach pain quickly progressed into violent seizures, and then he began vomiting. And in his vomit were 25 princess beads produced by the defendant. After Joey stopped vomiting, he fell into a coma. And at 1:50 p.m., his heart rate slowed, his breathing slowed, and at 2 p.m., he went into respiratory arrest, passing away at 2:02. Never again to be held in his mother's loving arms. Now, we as a plaintiff are charging the defendant with the suit of negligence per se. And as a plaintiff, we bear the burden of proof. And we must meet that burden with a preponderance of the evidence. Now, a preponderance of the evidence simply means that we must prove it is more likely than not. You can think of this as a scale. And if the scale tips even slightly in our favor, you must find the defendant is liable for the death of Joey Davis. At the beginning of today's trial, my co-counsel, John Gulledge, came before you, and he asked you to consider 3 questions. And each of those questions corresponds with one element of our burden. Now, the first question he asked you to consider was, did the defendant violate a law? The law in question today is the Midland Drug Abuse Prevention Control Act, the DAPC Act, which we brought to Emerson Zimmer on the stand, the former commissioner of the Department of Health, to discuss this law with you. Now, she told you that the law clearly outlines GHB and any of its precursors as Schedule I substances. And they are banned for use if they are used in a significant quantity, which clearly means anything that can increase the likelihood of death, serious personal disfigurement, or protracted loss or impairment of the function of any bodily member or organ. Now, Happy and Toy Company is trying to say that this law wasn't clear. But if they could have done more research, they can still be found in violation of this law. So consider the emails that Tristan Frost talked with you about. Now, in these emails, Erin Swift, the risk assessment officer at Happy and Toy Company, said that she hadn't researched the metabolic effects of GHB, of 1,4-butane-diol, and did Blake Lexington want more research on this issue? But in the email that Blake Lexington forwarded on to Quinn Brown, this bullet point is missing. Blake Lexington never ordered more research done, but they could have. They only spent 8 hours doing a risk assessment of this chemical. Furthermore, on the stand, Blake Lexington told you herself that they thought the law was somewhat unclear, but they decided not to hire a legal research team to advise them on this issue. Happy Land Toy Company violated the law when they used a Schedule I substance on their toy, the Princess Beads. We have proven this element of our burden. Now, the next question my co-counsel asked you to consider was, did Joey Davis suffer harm? Consider the testimony of Chase Tuckman. Joey Davis suffered from dizziness, seizures, vomiting, a coma, and then death. Any one of these symptoms can be considered harm. Joey Davis absolutely suffered harm today. Now, the last question my co-counsel asked you to consider was, did the defendant's violation of the law cause Joey Davis's harm? Now, this has 2 parts. We must prove that the defendant's violation directly and approximately caused Joey Davis's harm. So let's go through each of these separately. First, did the defendant's violation of the law directly cause Joey Davis's harm? For this, consider both the testimony of Chase Tuckman and Reese Gardner, the defense's own witness. Both Chase Tuckman and Reese Gardner told you that GHB causes many symptoms, including dizziness, loss of consciousness, and coma, all of which Joey Davis undisputedly suffered. And both of these expert witnesses said He had more than enough GHB in his system to cause each and every one of those symptoms. Now, furthermore, Chase Tuckman told you that Princess Beads caused Joey Davis's death. And the defense's own witness again said that was the most likely cause of Joey Davis's death. We don't have to meet this with scientific certainty. We must only prove that it is more likely than not, and we have done so today, ladies and gentlemen. The defendant's violation of the law absolutely directly caused Joey Davis's harm. So did the defendant's violation of the law proximately cause Joey Davis's harm? Now, for this, consider the material safety data sheet that we brought before you today. Now, proximate cause merely means could the defendant have foreseen the type of harm that was suffered? And if you look at the MSDS sheet, you'll see that it says health effects of 1,4-butanediol are all of the symptoms that Joey Davis suffered: nausea, dizziness, loss of consciousness. You can also look at the Princess Beads box. A warning that the defense put on there themselves may be toxic if swallowed. They absolutely knew that this product could harm children. Therefore, we have met all three elements of our burden today. Now, Happy Land Toy Company produced a toy that looked just like a toy until it took a child's life. Please find them liable. You can't see what you don't look for. You heard from multiple witnesses today that Happy Land Toy Company did not do enough research as they could. Because if they had done that research, they would have seen that 1,4-butanediol was a precursor to GHB and therefore was banned for use in Midlands. And more importantly, ignorance of the law is not an excuse. In today's case, ladies and gentlemen, we have proven that Happy Land Toy Company violated the law when they put 1,4-butanediol on their product, the Princess Beads. Now, opposing counsel just came before you, and he talked a lot about how we couldn't say for certain that Joey Davis died from the Princess Beads. But that's not the only harm he suffered in today's case. Let me recount for you again that he was dizzy, he seized, he vomited, and he fell into a coma, and both medical experts that took the stand today said that those were all consistent with GHB overdose and that Joey Davis absolutely had enough GHB in his system to cause every single one of those symptoms. Their violation of the law absolutely caused Joey Davis's harm. Now, opposing counsel also presented to you the affirmative defense of comparative fault. They're trying to say that Brett Miller could have done more, or that Andy Davis, Joey's mother, could have done more. But consider the fact that if Happy Land Toy Company had not coated their product in this dangerous chemical, and Brett Miller had left Joey Davis alone, and Joey had still swallowed the beads, nothing would have happened. But the fact of the matter is that Happy Land Toy Company did put 1,4-butanediol, a dangerous chemical, on the Princess Beads, and because of that fact, Joey Davis is no longer with us today. Ladies and gentlemen, it looked like just a toy, but it took a child's life. Please find them liable.
Ice Queen. What?